And thank you so much, Kathy, for the introduction, and welcome to all the new individuals joining us. We're pleased to have you, and we hope that you find today's conference beneficial and just an informative on what is happening, especially in light of the Janus decision. This morning, we're going to start off, or this afternoon, depending on where you're joining us from today, we're going to start off with an update from Jeff Jennings. Jeff has been a staff attorney with the foundation since 2014, when he received his law degree locally from George Mason University. During his time at the foundation, he has worked on the foundation's charter school initiative, handling any charter school case that comes to the foundation, and is, in essence, the go-to person for questions about charter school workplace rights. As part of his charter school oversight, Jeff has updated the pamphlet on charter school employees' workplace rights, and he will be speaking with us this morning and afternoon about those rights. Please feel free to contact Kathy Jones after the conference if you're interested in ordering the new free pamphlets. And now, without any delay, we will hear from Jeff on what has been taking place in charter schools.
Hi, my name is Jeff Jennings, and I'm a staff attorney at the National Right to Work Legal Defense Foundation. Today I'm going to talk about the Foundation's charter school initiative and then briefly discuss charter school employees' rights. Traditionally, unions have been opposed to charter schools. They viewed charter schools as trying to siphon off public funding from traditional public schools. And of course, traditional schools, public schools, have high rates of unionization and therefore greater sources for the union to collect membership dues and revenue. However, in recent years, the union has supplemented its opposition to charter school expansion by also trying to organize existing charter schools. In response to this growing unionization, the foundation created its charter school initiative to provide free legal aid to charter school employees who are facing issues of forced unionism, situations where the union is trying to force them to pay fees or otherwise be a union member. The foundation's charter school initiative not only provides free legal aid, but also creates educational programs like this one to educate charter school employees about what their rights truly are. We also attend the National Charter School Convention every year, as well as the California Charter School Convention. So if you plan to attend those events, please stop by our booth to say hi. Now I'll briefly discuss charter school employees' rights. Charter school employees' rights are really determined by how federal law classifies their charter school, whether it's a public school or a private charter school. The two relevant federal laws are the National Labor Relations Act and the First Amendment. The National Labor Relations Act is a federal law that covers private employers throughout the country. Private employers being those that are not controlled or owned by the government. And so the National Labor Relations Act also contains an exception for political subdivisions of states. So what that basically means is that state employers and local government employers, which includes traditional public schools, are not subject to the National Labor Relations Act or the National Labor Relations Board's jurisdiction, which is the federal agency which basically enforces the National Labor Relations Act. The NLRB, the National Labor Relations Board, uses a two-part test to determine whether a charter school falls within the political subdivision exception to the National Labor Relations Act. First, the board looks at whether the state or local government directly created the charter school. If that's the case, then more likely than not, the board would say that the charter school is a public charter school and exempt from the National Labor Relations Act. If not, then the board looks at how the charter schools board is structured, if the general electorate, the voters, or state officials have broad discretion in selecting the charter school's board members and also, or removing those board members, then again the board would likely say that it falls more into the political subdivision exception to the National Labor Relations Act and is a public charter school. If not, if neither of those factors are in place, then the board is more likely to say it's a private charter school subject to the National Labor Relations Act. The other federal law that's relevant is the First Amendment, and that matters a lot because it impacts whether the U.S. Supreme Court's case Janus versus ASME applies to a charter school. That's a case that the foundation won in 2018. There, the court basically said that it violates the First Amendment to force a government employee, like a school teacher, to pay fees to a union just to keep their job. But whether the First Amendment applies to your charter school is a complicated question, and you're encouraged to reach out to Foundation staff attorneys so we can provide you free legal aid and advice on whether the First Amendment might apply to your situation. So now that we've discussed the dichotomy between public charter schools and private charter schools, I'll briefly discuss the rights of private charter school employees, and then I'll also discuss the rights of public charter school employees. For private charter school employees, your rights fall into 3 general categories that we're going to discuss today. First, rights during an organizing drive. Second, rights regarding union membership. And third, rights regarding union fees. For organizing drives, unions will often go around to school employees and ask them to sign an authorization card. Unions need these cards to be signed so that they can petition the employer to recognize them being the union, as the exclusive bargaining representative for the employees. Or the union can take these cards to the National Labor Relations Board and ask the board to hold an election to see if the employees want to be unionized. Unions will often bully and intimidate employees into signing these cards, but it's important to know that you have every right not to sign an authorization card. And it's also important to read whatever it is the union is asking you to sign. Oftentimes, it will not be what the union claims that it is. Second, union membership. If the union does come into your school, you become unionized, you still have every right to stay a non-member of the union if that's what you want to do. And if you do choose to sign up for the union and later change your mind, you have the right to resign your union membership at any time. Rights regarding union fees are a little bit more complicated. Basically, it depends on whether you live in a right-to-work state or not. If you live in a right-to-work state, then you have a right to not pay any fees to the union. It would be illegal for the union and employer to have a job requirement or work rule that forces employees to pay fees to the union just to keep their job. However, if you live in a non-right-to-work state, it is legal for the union and employer to force employees to pay fees to keep their job. But the most that you can be forced to pay are fees that are related to collective bargaining activities. So you have a right to object to paying fees that are not related to collective bargaining. And employees who resign their union membership and object to paying for fees unrelated to collective bargaining, they usually see a reduction in the amount of fees that they pay. So that's a brief synopsis of private charter school employees' rights. Regarding public charter school employees, your rights are dependent upon state law. And state law oftentimes is similar to federal law and the types of protections it provides, but it can also be different. Because there's so many different state laws, it's recommended that you contact the foundation for free legal aid if you have questions about what your rights are in the state that you live. At a minimum, if you work in a right-to-work state, as a public charter school employee, you can't be forced to pay union fees just to keep your job. And if the First Amendment applies to your situation, then again, you can't be forced to pay fees regardless of where you live. So to wrap it all up, we're seeing more unions coming into charter schools. So it's important for charter school employees to learn their rights in advance, to educate themselves about these things. If you have any questions about what your rights are, please reach out to the foundation for free legal aid. Even if it's just us providing you advice on what your rights are, we're happy to help. You can do that by contacting us through our website. There's a form you can fill out to request free legal aid. You can also email us at legal@nrtw.org, or you can call our toll-free number. Additionally, our website contains a wealth of information about what employees' rights are on these issues, so I recommend that you check that out. Thanks for listening to this presentation.
Thank you for that presentation, Jeff, and we hope that it gave you a little oversight of what is currently happening in the charter school world. And something I didn't cover at the beginning, or even for those of you who are just now joining us, if you have any questions, please feel free to send them in. We would like to, be able to answer them if at all possible. One question that I have sent to me is, why do we believe unions are suddenly interested in charter schools? And that was something I covered kind of at the outset of when we had the video issues, is that, unions are starting to see that charter schools aren't leaving. They're here to stay for the time being. And so they're trying to figure out, well, how do we get those teachers and those individuals at that school district and make them part of the union, because for the union, many times it's the deeper pockets. Where do they get the money? And that's where they're turning to, because in light of Janus made public sector employees, right to work states in essence across the United States. So that's where the beauty of it is, individuals have this right as public teachers, say in California, in New York, where it's still a forced unionism state. And so unions are trying to look at where can they get more money to kind of protect themselves and make up for the losses that are there. For the booklets that I mentioned that, and I believe Jeff mentioned in his presentation, is that it gives charter school teachers and employees what their rights are if a union comes into place, and those are free. And yes, you can hand those out. They are available to anyone. And if you'd like a copy of them or just several to be able to distribute, you can contact Kathy and she can provide you with some of them. The other question that I'm seeing is, can you get somebody to come talk to teachers at your school? That is an option. The foundation, as we've discussed, Jeff, while he focuses on charter schools, there are other attorneys here. I'm one of them. We can travel and talk to teachers and employees about their rights and educating them, because half the battle these days is just informing people about what their rights are and what they can and can't do and what the union can and can't do when they're in place at a workplace. Another question that we are now being asked is, why are so many politicians under the union's control? Is it ideology or simply money? That's a great question that I don't know the answer to. It could be all the above. Use your imagination. There are probably studies out there that have done this. Unionization is a very difficult issue that we face these days, and people are on either side. We aren't, here at the foundation, we're not anti-union, we're just no forced unionism. You can't force a teacher to become a member of the union as a condition of employment, and making sure that they have these rights. And that was one of the things Janus did, protecting employees' First Amendment freedoms so that they can choose not to be a member of the union. One last question that we'll take before we turn to the next video, as it looks like we have one more minute, is what can the foundation do for charter schools facing a union election? Again, can we distribute your booklets? What can happen if they're facing election is contact a foundation attorney, please. We can talk about what can take place, what rights are at stake, for the teachers, what their options are in the midst of an election, and how they can proceed with the situation, because it is a delicate balance that you have when a union is starting to come in, try to get people to support them. So hopefully that gives you a little better idea about charter schools and rounding out the situation. So next we now turn to Bill Messenger. Bill has had quite an extensive experience here at the foundation, or career here, since receiving his law degree from George Washington University in 2001. Bill has worked at the foundation since that time, first serving as a law clerk and then a staff attorney. From the beginning of his career, he has focused on First Amendment issues, arguing multiple cases before the United States Supreme Court, including his latest and crowning achievement, successfully arguing the landmark Janus case last year in that court. We will now hear from Bill about that case and the impact it has since its release, and then after that I will answer questions related to Bill's presentation and then turn to mine.
Good afternoon, or good morning for those of you joining us from the West Coast. My name is Bill Messenger, and I'm an attorney with the Right to Work Foundation, and I'm excited to talk to you today about the Supreme Court's recent decision in Janus versus Ask Me Counsel 31, wherein the Supreme Court held it's unconstitutional under the First Amendment for the government to force any public employee to join a union or pay union dues as a condition of their employment. As a result of Janus, every public school teacher in the nation now has the right to choose whether or not they want to support a union. And today I'd like to talk to you about the background leading up to Janus and what steps come after Janus in terms of enforcing individuals' rights under that seminal Supreme Court decision. Now, to put the significance of Janus in perspective, it's important to look at what came before the decision. Before the court's decision in Janus, which happened in June of 2018, over 20 states in the nation were what's known as compulsory dues states, in which public employees, including public school teachers, were forced to pay union dues to keep their jobs. That includes in major states such as California, New York, Pennsylvania, Ohio. And all of those states, if someone wanted to work as a public school teacher or for a public school, generally speaking, that meant they had to pay dues to a National Education Association or American Federation of Teachers, or they were fired from their employment. And this state of affairs was blessed by the Supreme Court in a case called Abood versus Detroit Board of Education in 1977, where the Supreme Court upheld these types of compulsory union fee requirements. However, over 40 years, the National Right to Work Foundation, through its litigation program, attacked and chipped away at Abood, one piece at a time, over and over with one lawsuit after another, challenging the very foundations of compulsory unionism in the public sector, until eventually that foundation began to crack in 2012 in a series of 3 Foundation 1 cases that ultimately culminated in Janus. The first was in 2012 in the Supreme Court's decision in Knox, where it called Abood a First Amendment anomaly and questioned the legal foundations of that case. That was followed in 2014 by another foundation case known as Harris versus Quinn, where the Supreme Court effectively held that Abood was most likely wrongly decided and the compulsory union fees in the public sector should be unconstitutional, but the court wasn't able to overrule Abood in that case because it didn't directly involve public employees, but rather a different type of employee, independent Medicaid providers. And then finally came the death blow to compulsory unionism in the public sector in Janus in 2018, where the Supreme Court held it was unconstitutional to force any public employee to pay union dues or fees without their affirmative consent. And to put in sort of perspective the significance of that decision, prior to Janus, we estimate that roughly 5 million public employees, many of whom were public school teachers, were forced to pay union dues to keep their jobs. As a result of Janus, all of those 5 million public employees now have the right to choose whether or not they want to pay union dues or to not pay union dues. And they can no longer be forced to pay compulsory union fees against their will. However, the court's decision in Janus is not the end of the story. The union resistance, unfortunately, continues, and there is a great deal of litigation that has followed in the wake of the Supreme Court's decision in Janus. And to discuss that today, I like to put it basically in 3 categories just for analytical purposes. Retroactive relief for those who had compulsory fees taken from them prior to Janus, enforcing individuals' rights under Janus to opt out of the union and cease paying union dues if that's their choice, and then litigation to extend Janus to new areas. Now first, let's start with retroactivity. Supreme Court decisions are, as a general matter, retroactive. So when the Supreme Court held it was unconstitutional to force public school teachers and others to pay compulsory union fees in Janus, what it was saying was it was always unconstitutional to force employees to pay those union dues against their will, and that Abood had been wrong for the last 40 years. So what that meant is that many employees had their rights violated for decades, if not more. Unfortunately, we can't reach back and collect all the dues that unions wrongfully seized from employees because of the statute of limitations. But we can sue going back to 2 years or 3 years, depending on the state. And right now there are over 4 dozen lawsuits currently pending that are seeking to recover fees wrongfully taken from public school teachers and other public employees prior to Janus without their consent. And these cases are pending all across the nation, most of which are in district courts and is filed as class actions. A large number of these cases are being brought by the National Right to Work Foundation. Now, whether or not these lawsuits will ultimately be successful is yet to be determined. The cases are still being litigated. The key issue in most of these cases, it's what's known as the good faith defense. The union is arguing, or unions I should say, are arguing they don't have to give back the money if they had a good faith belief at the time that it was legal to take a teacher's money or other public employees' money under the law that existed prior to Janus. Our position is there is no such thing as a good faith defense. If someone mistakenly but unlawfully takes someone's property, the law is usually they have to give that money back. They don't get to keep it by saying they had a good faith but wrong belief if the money was in fact theirs. So there's a significant amount of what we call relief at stake in these cases, and these cases are currently working their way up the legal system, And I would expect over the next year or two we'll see decisions by the appellate courts and potentially even by the Supreme Court that resolves whether or not the unions have to give back the tens of millions of dollars they wrongfully took from employees prior to the Supreme Court's decision in Janus. The second category of cases are cases to enforce employees' rights under Janus. Now, Janus said it's unconstitutional for a public employer or union to take any public employee's money without their consent. So what that meant is any individual who was a non-member when Janus was decided, or who never decided to become a union member, the unions by and large across the nation have ceased taking dues from those individuals because the court's decision in Janus was so clear-cut on that point. But where the unions are resisting this decision are for individuals who were union members at the time Janus was decided or thereafter, and who authorized dues deductions. Now, in almost all states that had compulsory union fees, they also authorized automatic dues deductions. So individuals who chose to be union members signed a document that said, I agree to have union dues deducted from my wages. Now, at that time, they didn't really have much of a choice because the alternative was to have forced fees taken even if they didn't agree. The problem that has come up is that unions are saying, and many public employers, that employees cannot revoke these dues deduction authorizations except for certain escape periods, once per year. The most common is to say you can only stop dues deductions during one 10-day period per year. But for the other 355 days of the year, an employee is forbidden from exercising their rights under Janus and from stopping the seizure of union dues from their paycheck. In some states, this has actually been codified as a matter of law. So, for example, New Jersey passed a law that literally says that no public employer can stop the deduction of dues unless the request to stop the deduction is made during this 10-day period per year. In other states, it varies by the language in the contract. But this is a significant impediment on individuals' First Amendment rights under Janus because many people sign these cards under duress or because they were required to pay dues at the time, and now the unions and public employers are saying, we're not letting you stop. Currently, there are over 30 lawsuits pending nationwide challenging these escape periods that unions and their allies have been imposing on teachers and others, saying that it's unconstitutional for the unions to restrict when an employee can exercise their First Amendment rights. Because under Janus, an employee should have a right to decide at any time whether or not they want to stop paying union fees. And states and unions shouldn't be able to restrict that right to only 10 days per year. However, much like the retroactivity cases, these cases are still in their infancy. Most were filed, almost all were filed, in fact, after the Supreme Court's decision in Janus in June of 2018. So these cases are working their way up the legal system, most of which are district courts now, but again, I expect over the next year or two or three, we'll see decisions from the appellate courts and perhaps ultimately by the Supreme Court ruling on whether or not these escape periods for when teachers and others can exercise their Janus rights are in fact unconstitutional. Now, if you're a teacher, which you probably are if you're listening to this to me today, and you want to exercise your rights under Janus, but you're currently having dues deducted from your paycheck, and you're wondering, what are your options? Your options, what I would recommend is to go to a website called My Janus Rights, or to the National Right to Work's website, and there's a sample letter in which an individual can request that they want out of the union and they want the dues deductions to stop. And if the public employer or the union says you can only stop during a certain window period, at that point you should contact the Right to Work Foundation for free legal assistance on what your options are to potentially challenge that union escape period. Because as mentioned before, this is occurring all across the nation of this restriction on individuals' rights to stop dues deduction if they had authorized it in the past. So the final category of cases is extending Janus to other areas. And the big issue here is exclusive union representation. Even after Janus, even though public school teachers can no longer be forced to pay union dues, they are still forced to accept compulsory union representation, known as monopoly representation or exclusive representation. And this is where the government gives the union the ability to both speak and contract for every public employer or every public school teacher in a bargaining unit, whether they like it or not. There's questions about whether or not that is now challengeable in the wake of Janus, because if individuals can't be forced to pay dues to a union to keep their job, why is it constitutional to force them to accept a union as their agent and spokesman as a condition of keeping their job? Right now, the Right to Work Foundation has 2 cases that is sort of testing the waters on this area, and what they're doing is they're challenging exclusive representation of non-employee Medicaid providers and child care providers. The idea being that if the Supreme Court is willing to hold it unconstitutional to compel these individuals to accept an exclusive union representative, then that signals that the court may be amenable to looking at whether exclusive representation of public employees is in fact constitutional. There's also questions about whether or not private sector employees, including private sector teachers, can be forced to pay union dues against their will. And that'll most likely be another issue going forward in the coming years that may be litigated post-Janus. So to recap, Janus held it's unconstitutional for the government to force any public school teacher or any public employee to pay compulsory union fees against their will. Under Janus, every teacher, a public school teacher, and other public employee now has the right to choose whether or not they want to join a union and pay union dues or not join a union and not pay anything as a condition of their employment. However, there's a lot of litigation still going on to sort out exactly how Janus will be enforced in the future. This includes whether or not teachers and others can receive monies taken from them prior to Janus in violation of their rights, whether unions and public employers can put restrictions on when employees and teachers can exercise their First Amendment rights under Janus going forward, and then finally, how Janus can be enforced in other areas. For example, perhaps attacking exclusive representation and moving Janus to the private sector becomes a potential area of future litigation. And so that's a general summary of what happened in Janus and the post-Janus world. And if there are any questions, please email them to your host today. And I hope you enjoy the rest of the conference. Thank you. Thank you.
Thank you, Bill, for that update. That was tremendous, and hopefully you all have a little bit better idea of what took place in Janus and the aftermath of it as cases are continuing to be filed. As you heard, we're still dealing with individuals trying to get their money back, the clawback cases that were presented today. You will also see, I believe a poll just popped it up on your screen. If you would take a moment and answer that, that would be appreciated. As you're doing that, and I know a lot of us are great multitaskers, I'm going to just kind of go through some of the questions that have come up from Bill's presentation. The first one is, we've always had a problem getting equal access to teacher mailboxes and email addresses so that we can communicate with them. Is there any way the foundation can help us with this problem? Would it be a First Amendment issue in there? Please, thank you. That's an interesting question because many times access is dependent upon who else gets that information. Do the unions get them? What does the rule book provide for? Things like that. So it's not, it would be a case-by-case situation, I believe. So we would always encourage someone to, fill out an inquiry form and contact the foundation so that we can talk to them in more detail about that and give more specifics about their situation. The next question is, while state laws can trump this, can state laws, apologize one second, will state laws trump the Supreme Court decision? Will all of these countermeasures the unions are trying to put through state legislatures dilute or simply make Janus void in those states? States cannot trump First Amendment rights. Those rights are provided to every citizen of the United States. So while states may attempt to find ways around the Janus decision, they cannot require employees to pay dues as a condition of employment. They can try to, as you've heard Bill discuss, have check-off authorizations that restrict people from revoking them for a year, which they're already doing. They can do other avenues around it, and I'm sure in their view, weaken the impact of Janus, but at the core base of it, Janus is out there stating that individuals have First Amendment freedoms. The only thing that could overturn Janus would be the Supreme Court itself, which is very rare. They rarely rule against themselves, which again, this case was an interesting nuance in the scheme of things. There's arguments on whether or not they overruled the prior decisions, things like that. But as you heard Bill say, it kind of was a step approach in cases that never per se directly addressed the First Amendment issue and whether it was a First Amendment violation in the first instance. And here, the court held it was a First Amendment violation. So time will tell what states continue to do and if they will continue to try these like runarounds of the Janus decision. The next question is, why did Janus only cover public sector unions if we are all guaranteed First Amendment rights? The reason it only covered public sector unions is that the First Amendment is a violation if the government violates it. And here the government was public sector employees, was forcing individuals to have a representative speak for it on its behalf to the government. And so that's where it's only covering public sector employees and it doesn't impact private sector employees because an employer doesn't necessarily violate a First Amendment rights because they have no responsibility there per se. The last question is there a possibility a Supreme Court decision could end exclusive representation? Yes, it is a possibility. As you've heard Bill mention, we've got some cases in the pipeline that are going up that way, and we're hopeful that the court will rule on it and will take those cases and not just simply deny certiorari. That's what it's called when you petition the Supreme Court for review of a decision. You ask them to take the time, in essence, to review the decision, hear oral arguments, and it's called the cert petition. So hopefully they will grant the cert petition and continue to address that issue, because that's another question is, okay, if a union is at the workplace, do they have the right to be the exclusive representative for people who do not want it to represent them? So I will now transition into Michigan, because as Kathy stated at the very beginning of the conference, Michigan has been kind of a little test area of what it would look like if Janus won, if we won Janus, and we did. And Michigan has been a right-to-work state since 2013, on March 28th of 2013, specifically in the public sector as well as in the private sector. So individuals in Michigan and private sector don't have to pay dues as a condition of employment. However, the interesting factor was that 5 years later, and almost 5.5, 6 years later, we're still dealing with cases in Michigan. And this last year has been an exciting year in Michigan. We've had some settlements, we've had some great victories, and we even had a federal class action case settle that was filed after Janus. And I'm going to kind of go through that process and explain to you what that has looked like and kind of give you an idea of, even though Janus was won, it's not over yet. We are still facing issues, as you've heard Bill discuss, the clawback issue of getting people their money back. We're also facing the issue of getting people out of checkoff authorizations, things like that. So in Michigan, near the end of last year, we filed a federal class action complaint against Michigan Education Association. Now, we've had a lot of cases against MEA since 2013 because they initially had what was called a window period. They claimed that you could only resign your union membership during an August window period. We brought a case, several cases, some you'll hear me discuss today, challenging that since 2013, and the Michigan Court of Appeals and then the Supreme Court denied review of Michigan of that case, held that MEA can't have a window period. It's illegal to violate an individual's right to refrain. So that when MEA was denying people who resigned in September or November, December, the court held that they had to honor those resignations and they could no longer demand dues from them. Well, fast forward 5 years, 6 years now, and MEA is still demanding dues from individuals. Two individuals specifically, Linda Gervais and Tammy Williams, are Michigan employees, and they had been receiving demands that they pay dues after they had resigned in 2013, both of them in September of 2013 to be precise. And they were willing to move forward and file a class action settlement in the hopes to get relief for all teachers across Michigan, not just teachers, public sector employees who were having this harassment by MEA for dues that they had no legal obligation to pay and MEA had no legal right to demand. And as a result, MEA settled with them and said that they would honor their resignations back to September and that they would stop demanding and that they would withdraw the demand and threat that they would send them to collections, because that's what MEA has been doing. They said they would send people to collections if they didn't pay these dues that they didn't owe in the first instance. And the other unique thing about this class action settlement was that the MEA said that they would extend the same settlement terms to individuals for the next 12 months, meaning until January 30th of 2020. If an individual comes forward who has resigned their union membership and MEA is demanding dues from that individual after that resignation, then MEA would extend those terms to that individual. And we've been receiving a lot of calls about that and helping as many individuals as we can under that. And that class action case was filed on the basis of Janus, because Janus held that an employee and union cannot demand dues or fees from an individual who is not a member. In addition to that settlement, we also, as I mentioned, had prior to these cases and prior to Janus, filed a lot of cases challenging MEA's August-only window period. And we had about 7 of those cases still outstanding, and we were able to settle those for all of those teachers and public school employees, with one individual receiving $500 in dues back and another one receiving $250 in dues back. And those were tremendous, because those are clients to have worked, with someone for 5.5 years, and to finally get them a result that they were all happy with was just a great result. But again, that's just an example to show you that 5.5 years after MEA Michigan became right to work, we were still dealing with cases and still dealing with people's the violation of people's rights to refrain from union membership and paying dues. In addition to those settlements of those 7 cases and the class action settlement, we had 3 other settlements that were reached for 2 other individuals who, one, Michigan Education Association had actually taken into court, state court, suing them for, under their terms, of breach of contract, because they had signed a membership application, and MEA claimed that the individual never resigned, yet the individual actually had record of 2 emails sending to MEA resigning, and then the other individual, she had a record of sending a certified mail letter to the union resigning. And in both instances, we were able to get the union to settle and say that, those individuals resigned and that MEA would no longer demand those dues from them after their resignation. So those were the big settlements, one as a direct result of Janus, that were exciting this year in Michigan. The other 2 things that were a great thing, and if you were part of last year's conference, you heard from Ron Conwell. He is a Michigan public sector teacher who in 2015, mind you, that's 2 years after the Right to Work law's effective date, resigned from his union membership, only to then have the union, which was again MEA in this instance, come back to him and say, you can't resign, you are under a contract that requires you to pay dues as a condition of employment. We sued MEA and the school district for entering into contract, because they entered into a contract in 2015 containing a compulsory unionism clause and demanded that he pay the dues. And we successfully won before MERC, and MEA appealed to the Michigan Court of Appeals. And in January of this year, the Michigan Court of Appeals upheld our victory, saying no, the school district, which had actually did not appeal to the Court of Appeals, but the Michigan Court of Appeals held that MEA could not enforce a contract after the Right to Work law's effective date demanding an employee pay dues as a condition of employment, nor could it enter into a contract containing such terms. And so that was a great victory in that case. And the other neat kind of aspect of that case was that it was the first case ordering a school district and union to pay a $500 civil fine to the state for its violation of the individual's rights to work. And while $500 doesn't seem much, in MERC and the way the Michigan system works, you don't get money back, and you can't get money for your clients unless they had outlaid money. And in this case, neither one, Ron had not. So it was just something to have, where the court upheld and the Michigan Court of Appeals said, yes, it was appropriate to issue a civil fine in this case. The other great victory in Michigan Court of Appeals just happened this month in a similar situation. 2 public sector teachers had also resigned and revoked their union membership after the Right to Work law's effective date. And the school district had a collective bargaining agreement or agreements containing an agency shop clause. And similar to Conwell, the Court of Appeals said, no, you can't enforce that requirement after the Right to Work law's effective date. So in essence, it means public sector employees have the right after March 20th of 2013 not to pay dues to a union and as a condition of employment, a right we've all known is there, but just to have the Court of Appeals affirm that right and state in 2 cases this year, albeit unpublished. So it'll be interesting to see if that a different, court or outcome a different outcome comes out in other cases. But those are the big things that have been happening in Michigan, and hopefully give you an insight of why it's still an issue. Like, even though we've won, you still have to keep your eyes open. And if someone believes their rights are being violated, contact us, because we can help or just get information to the individuals out there. So I believe there's about 3 questions on what I discussed. The first one being, if we have teachers kind of trapped in window periods, should they contact you? Yes, because it depends on the window period that they're trapped in. It depends on, is it a checkoff authorization? Is it a resignation window period? Is it a revocation window period? Things like that. So as you can tell, a lot of questions come up, and each person's situation is very different. It might fall within what we've already addressed, or even one of the clawback cases that you heard Bill discuss, or one of the other cases that we have. The second question is, what is the best thing for us to do if a teacher comes to us and says the union will not let them resign? The best thing is, again, I feel like a broken record at this point, have them contact us, because an individual has the right to resign at any time, and a union cannot restrict that right. And questions will need to be asked, information gathered to figure out, okay, what is the reason for resigning? Because many times it's not that the union won't let them resign, it's that the union won't let them revoke a checkoff authorization that they have signed, authorizing the automatic payment of dues or deduction of dues from their paycheck and to the union. So there's more at stake here, and terminology can get mixed up when people are asking what their rights are and information. The next question is, can you think of any other ways unions can keep teachers in that unions themselves have not come up with? Oh, I'm sure I can. I'd just rather not discuss that and provide that information out there, so that, if they haven't thought of it, I don't want to be the one to provide it. But if you think, your rights are being violated, or if they're restricting your rights, or if you're wondering, is this new way of doing something is legal, please contact us. And then the last question is, what if the union does not stop deducting my dues after I've resigned? Is that on the union or on the district? That's an interesting nuance, because again, you've heard me say this, a checkoff authorization. The question turns on whether or not you signed a checkoff authorization form and what's in that form. And it is actually on both the union and the district responsibility. Mainly, our argument is that the checkoff authorization is a contract between the employee and the school district, authorizing the school district to deduct those dues. But yet many times employees will kind of claim our hands are tied, we're bound by the union, we have to do this. And so that's where each situation is very important, and contact us, because if there's a window period for checkoff authorizations, that's different than a window period for resignations, which a window period for resignation in MEA has been struck down, but that hasn't occurred in checkoff authorizations yet. So please contact us if you have questions about that, and we can hopefully answer your questions on those issues. So those are the only questions on this. So we will actually be turning now to Larry Sands. He is going to be presenting the next segment for us. Larry Sands is a retired teacher who, since 2009, has served as the president of the non-union California Teachers Empowerment Network and has appeared on national television. He is also a widely known speaker on teachers' unions as blocks to education reform. Today, he will be talking mostly about the spate of teacher strikes. And if you would like to receive updates from Larry on the situation or any other thing that he addresses, you can sign up to receive his weekly column at California Policy Review. And without further delay, here is Larry.
Okay, thank you very much. Okay, I'm going to talk a little bit about the recent strikes, 2 of them specifically, the one we had here in Los Angeles and the one in West Virginia. And UTLA, the United Teachers of Los Angeles boss, Alex Caputo Pearl, began his long march back in 2016 when he forecast a walkout and also boasted about the union's ability to create a state crisis in 2018. Though he threatened a state crisis, the UTLA honcho interestingly ignored the one that is right here, right under his nose in Los Angeles, excuse me, where 52% of LA schools earned a D or an F in English and language arts, and 50% earned a D or an F in math, and only 40% of all students who graduate are college and career ready. according to the California School Dashboard. I would call that an education crisis. Okay, so the 2018 strike actually got here in January 2019. He was off not by much, and the stated strike issues are pay, class size, the usual stuff. You've heard it all before. These, as I say, were the stated issues. The strike was really more about other things. It was more about charter schools. In fact, on the second day of the strike, the union did not picket the school district, they picketed the California Charter School Association building. It's understandable that the union wants to get rid of charter schools because charter schools do a better job than the traditional unionized public schools do. 50 days of learning and reading and 79 days in math in a typical year. And charters do this on only 73% of the funding that traditional public schools get in Los Angeles. And part of the strike deal, the demands of the union went toward anti-charter school legislation, which is now going through the legislative meat grinder in Sacramento. And unlike Jerry Brown, who may not have been the greatest governor in the world in California, but the new guy is worse. Gavin Newsom is a friend of the union, and he won't veto probably anything anti-charter that the legislature will pass. Computer Pearl and many other unionistas love to make our charter schools seem like vampires that suck blood from traditional public schools, but charters only account for 13% of the district's enrollment drop in 2017 and 2018. The real problems here are pensions, that's on the statewide, and LAUSD, the school district's unsustainable healthcare plan. Their unfunded liabilities for retiree healthcare benefits has risen to $15.2 billion. LAUSD spends more than $300 million a year on healthcare subsidies for retired employees, including retirees like me, who are already entitled to Medicare. And if the district were to cut these unnecessary insurance expenses, the money could be put back into the classroom. But the Health Benefits Committee, stocked with union people, which determines employee and retiree health plans, has nixed the idea. It's very possible that the county and or state will take over soon because the district could be broke by 2021. But to mitigate against all this, we're going to tax people. They're going to try to tax people, I should say, more. I have a parcel tax coming this June, which will ding just about every homeowner in Los Angeles for the next 12 years. And we have a split roll, which will ding commercial owners more money in 2020. So the strike was about money and charter schools. It was also about Alex Caputo Pearl becoming CTA president. In 1989, Wayne Johnson was president of UTLA and conducted a strike over 8 days or 9 days, and he went on to become the California Teacher Association president, and I think Caputo Pearl is working from that script. The strike was more about making a statement about Janus and union power. Also, many teachers really hated the deal. The contract that they got was nothing better than what the district was offering. For example, the union could have accepted the pay offer that they ultimately got without striking. The union leadership failed miserably here. While teachers gained 2-3% raises, this year's raise was completely negated as they won't get paid for the time they missed while on strike. The schools had remained open. The rankers class size issue is pretty much a nothing burger. The new contract stipulates that in grades 4 through 12, class size would be reduced by 1 student each of the next 2 years and 2 more students in 21-22. The teacher on Facebook went ballistic when she read this, sarcastically claiming how much better she'd be able to sleep knowing that her class size would go from 28 to 27 next year. In fact, the UTLA Facebook was home to teacher rage, including many educators who would have voted against the new contract had the window to cast their ballot not been so short. After the contract was agreed to by the union elite, Mike Antonucci wrote, had this exact tentative agreement been offered 2 weeks ago, the union would have rejected it. Antonucci is right. The whole mess was about theatrics, the ascendancy of Alex Caputo Pearl, to CTA presidency, the positioning of the union as vital to teachers in the wake of the Janus decision, and sending a message to Governor Gavin Newsom that we need to spend more, and more taxpayer dollars on education. Now, shortly after the LA strike, we had a strike in West Virginia, and it was actually the second strike in a year. Now, just a little backstory here. West Virginia public schools are not very good. According to the state scorecard, 88% of the state's 116 high schools do not meet standards in math. Furthermore, the state's eighth graders ranked 45th nationwide in reading, as per the 2017 National Association of Education Progress, also known as NAEP. And with these dismal numbers in mind, the legislators decided that things needed to be shaken up. So enter SB 451, which permitted up to 2,500 educational savings accounts for families with an annual income below $150,000 and allowed for the establishment of charter schools. West Virginia is just one of 7 states with no charters. An early version of the bill would have eliminated seniority as a sole criteria for deciding reductions in force and required annual approval before unions could deduct dues from employee paychecks. Following the prodding of the teachers union, the bill was gutted in the House and then morphed and morphed again. The subsequent version provided for the creation of just 7 charter schools nationwide and 1,000 ESAs for students with special needs or those who had been bullied. Yet, even with these modifications, the thought of any competition from charter schools and ESAs trumped money and other perks for teachers. So, for the second time in a year, the teachers of West Virginia went on a statewide strike, not about money, about charter schools and ESAs. The legislature promptly caved and the bill died. Now, the reality is for education to improve, it desperately needs competition. West Virginia's Senate President Mitch Carmichael, who strongly backed the reform bill, stated the obvious when he claimed that their education system needs to be overhauled. He said he believes creating competition by introducing charter schools and allowing families to use public funds in private schools would force traditional public schools to perform better, he added. If there's competition and choice, it raises the level of everyone involved. It's been proven time and again that Carmichael is right. When competition is introduced, traditional public schools invariably get better. But in West Virginia, a powerful special interest leaned on compliant legislators who then ruled to maintain the failing status quo, thus sustaining the big union monopoly. Back in 2012, former California State Senate leader Don Parada opined that the California Teachers Association considers itself the 4th co-equal branch of government. He's right, it is. And it seems that West Virginia has now officially joined that club. With the success of charters and the success of the Janus case, the teachers' unions have a new emphasis: killing competition and showing union doubters just how bad they can be. Welcome to 2019. I thank you for listening.
Thank you, Larry, for that presentation. And my understanding is you're going to be able to answer some of the questions that we have.
Sure.
Now, okay. So I'm just going to shoot them to you, a few of them at a time. First question is, why did the teachers go along with the strike deal if they weren't crazy about it or didn't get what they personally wanted?
Well, it's debatable how many did, and one of the problems is they rushed the vote. The vote was like hours after the union agreed to make the deal, and a lot of teachers were very, very angry. And there's no way to know, it's too late now, how many teachers would have voted against the contract.
Okay. And then the next question is, why do teachers stay with UTLA after what happened, with that, what this person called the farce of a strike? And do you think they know that they have the right to resign?
They might know it, but there's trap language, because when Janus was looming, UTLA did what many unions did across the country and hooked teachers in for another year. And teachers are furious about it. There are lawsuits. There was a lawsuit filed by somebody by the name of Tommy Few. He did it first, and he wanted to stop paying immediately, and he wanted to get back a few months worth because he resigned and they didn't pay any attention to him. And lo and behold, the union paid him and said something to the effect, well, we don't think you're right, but we don't want to waste dues money on litigation, so we're just going to accede to your wishes. That may not have been a good idea for the union, because now there are a lot more lawsuits coming down the pike. So your question is, time will tell. We're just going to have to wait and see how many teachers leave the union, but it's going to be a lot more than have done so far because of the trap language.
Okay. And I will say this, many times unions like to try to settle if they think there's only one individual coming forward. And then as a result of that one, there's usually an avalanche many times that they experience.
Right.
The next few questions are somewhat related. It says, how has your group responded to the new mood of Red for Ed pound has engendered?
I'm sorry, could you repeat that? I couldn't quite hear you.
Yes. How has your group responded to the new mood, the new Red for Ed that has been engendered?
How has my group responded?
Yes.
Not too much. Our people are very independent, and they just want to be teachers and left alone. And most of our people don't mind their locals. They just hate being part of CTA and NEA. So they've been going doing their work. So I really can't give you a specific answer. I don't think it's had much of an effect on them, no.
Okay. Next question is, are there any movements underway to make strikes illegal in California that you're aware of?
To make what in California?
Strikes illegal in California?
In this state? Well, California will be the last state to make strikes illegal. No, not in the least. We leave that to red states. We're a bluer than blue state.
Yeah, I think New York is right there with them. Yeah. Next question is, have you noticed union officials stepping up one-on-one action in your state after Janice, in example, visiting your members, having more contact with teachers at your schools?
I've heard some reports that yes, the unions all of a sudden realize that they can't use every teacher as an ATM. So yeah, they're doing what everybody else does, trying to convince people that they're worthy of their $1,000 a year dues. So yeah, and after we get rid of the trap language and people start leaving en masse, these efforts will probably be stepped up, because not many teachers are leaving now, as I said before, due to the trap language.
Okay. One more question. Well, we actually have two more questions, but one is, what can we do about strikes? Are teachers legally compelled to strike if they belong to the union?
It's my understanding that if a teacher is in the union and they do not strike, they can be penalized. I don't know that this has actually been upheld, but I believe the union has a right to do that.
Yes, and I can actually somewhat answer the legal side of that. Is if you're a union member, yes, you are a union member. You are subject to the internal union rules and requirements. And so just what Larry said, you can be penalized internally. Now you can resign and revoke membership and then cross the picket line, but you cannot cross the picket line until you've submitted that resignation, because like Larry said, and the law usually is that you can be penalized internally if you are a union member.
Right. I know quite a few people who did cross the picket line who are not union members, and there's nothing legally the union can do. Of course, you can be ostracized. You can, maybe leave your school without a windshield, but legally there's nothing the union can do if you don't go along with the strike and you're not a union member.
Good point. And either windshield or, slash tires, I've heard of those, or, scabs, things like that.
All the above, yes.
Yeah, all the good lists, the list goes on. And that's what I tell people, you know what, I can sit here and we can sit here telling you what the law is, but you live there, you have to provide for your family. Make the decision that's best for your family and you in that instance, because you know what the life on the ground is like. And the last question, somewhat funny, is someone would like to know, who are the people featured in the photograph behind you, if you are willing to say?
The people who are in the photographs behind me?
I think I know. You do not have to answer it. It was just.
Well, there's one. I mean, I don't know because I can't see the picture, but I'm pictures. As a matter, a picture of me with David Horowitz, and my favorite picture is a picture of an award I got from the National Right to Work Foundation last year for my writing. It's right up on my wall, right under the picture of me with David Horowitz, if you can see that.
We can, and thank you for answering that. I know it was a off-the-cuff question. Thank you for your time, Larry. I really appreciate it. Those are the only questions we have. Is there anything else you would like to say that you feel that either the questions made you think of or you didn't have a chance to say?
Just that teachers need to learn their rights and step up and not be afraid. There are so many teachers who are afraid. Teachers and parents in West Virginia are really afraid because the strikers are vicious. Not all of them, but many are, and it's cowing people. And I mean, the only way to stop bullying is to stand up to the bullies. And so I just would implore people, teachers, parents, do not take what the union is handing out if you don't feel it's correct.
Fantastic. Thank you so much, Larry, for your time. I truly appreciate it, and I hope you can enjoy the rest of your Saturday.
Will do. Thank you, Amanda.
All right. Next, we are now going to turn to our last presentation today. We're actually making a little faster time. The videos are shorter this year, so that you can all hopefully get back to enjoying your Saturday and after having already enjoyed it with this conference. The next presenter is someone you all may be familiar with if you've been at the conference before. He used to be my co-host, Nathan McGrath. He worked at the foundation as a staff attorney from 2012 to 2016. However, he left, where he currently is serving as Vice President and Litigation Counsel for the Fairness Center in Harrisburg, Pennsylvania. The Fairness Center is a nonprofit public interest law firm offering free legal services to those hurt by public employee union officials. The Fairness Center attorneys provide clients with a voice in the court of law and the court of public opinion. Pennsylvania, which is where the Fairness Center is located, was formerly an agency shop or forced dues state for teachers, so that teachers there have the benefit of the Janus decision, permitting them the right to not pay a union as a condition of employment. In this next segment, we will hear from Nathan and learn more about the cases that he is handling and possibly some more about the impact Janus has up there.
Hi, my name is Nathan McGrath, and I'm Vice President and Director of Litigation here at the Fairness Center. Today, I'm not able to be with you live. Typically, I'm there to be able to co-host this important conference, but wasn't able to get away with this year. But with that said, they have given me some time to share with you what we're doing here at the Fairness Center, and so I'm excited to get into that. But before I do, I just wanted to say the CEAFU conference is so important for a couple of reasons. The first being that you get to hear from industry leaders what's going on in this area of law with legislation and trends and patterns and a lot of really interesting things. Also, you get to get your questions answered. And then thirdly, you get to build community and relationships that hopefully last for a long time and that are useful to you in what you do. So with that being said, let's go ahead to the conference room and we'll get started with my part of the presentation. So today we're going to talk about some post-Janus litigation that the Fairness Center is involved in, and we're also going to talk about an issue called maintenance of membership that I think is really of national importance, and certainly for you teachers and those of you who run organization groups that care for teachers and take care of them. This is also an issue that you want to know about, and you want to know basically the trends, what's going on, and what's happening there. But before I get to that, you may be wondering, what is the Fairness Center? Well, the Fairness Center is a public interest law firm. We have the great pleasure of representing those who are hurt by public sector union officials, and we do that for free representation for them. Currently, we are based in Pennsylvania. but we are set up in a way that we can grow nationally. We've moved into Connecticut. We have some cases and clients up there. So it's really fun for us. We love our clients, and we just really enjoy what we get to do. So that's the Fairness Center. And the first case that I'd like to talk with you about kind of on our journey today is called HeartNet v. PSEA. It's Pennsylvania State Education Association. It's the state affiliate of the NEA, the National Education Association, as I'm sure you all are familiar with. And in this case, we have 4 clients, and we're actually representing them alongside some National Right to Work attorneys as well in this case. And this case is filed in federal court, and really how it is structured, it was challenging compulsory fees, just like Janus was. And so Janus, of course, beat this case up to the Supreme Court. Not that it was a race or anything, but it was just ahead of it in the timing. And so what this case now has become is really an enforcement case. I like to talk about it as, HeartNet. Our case there is important because it's bringing Janus to Pennsylvania. So what our clients are doing in this case, they're asking the court to strike down Pennsylvania's fair share fee law, and just generally to make sure that Janus is applied here in Pennsylvania. So this case is still sitting before a federal court judge in the district court, and we could really get the opinion there any day. The union, of course, is arguing that this case is moot because of Janus, and our clients are arguing, well, Janus was great, but we need to make sure Pennsylvania, all the I's are dotted and T's are crossed, making sure that Janus rights are here in Pennsylvania. So that's the HeartNet case. And so the next case I'm going to talk about, we refer to these as our religious objector cases, and we have 3 clients here: Jane Ladley, Chris Meyer, and Linda Mizja. And these are folks who were not members of the union, and they were religious objectors, and they wanted to send their fees to a charity, of course. And what happened is they told the union, this is a charity I want to send them to, and the union said no, and the union put up some other procedural roadblocks in the way. Now in Pennsylvania, it's very interesting. The law that governs this says that the union and the religious objector have to agree upon the charity that they send the fees to. As you may imagine, that sometimes gets difficult, and no one really knows how that tie gets broken. That's part of what our clients were seeking with their cases. Now, Linda's case was filed in federal court, and Jane and Chris's case was filed in Pennsylvania State Court, and that case is actually moved up to a court of appeals. But just like with the HeartNet case, these cases have taken on a new angle as well, because the Janus case came out saying that these folks can't be charged any compulsory fees, and so now the union is trying to get rid of the cases, and of course our clients are saying, no, we still need to clean up this mess and make sure that Janus rights apply in Pennsylvania. So very interesting cases. Again, they're slowly moving their way through court. Now, I want to talk with you for a moment about the issue of maintenance and membership. Like I said at the beginning, this is a national issue. We're seeing this all across the country, and a very important one. And that's, I'll explain that in a second, but first we should talk about what is maintenance and membership. Well, it's somewhat self-explanatory in that you have to maintain or keep your membership for a certain amount of time, period. You can't get out of a union once you are a union member. And so here in Pennsylvania, we actually have a maintenance and membership statute, and the law allows unions to negotiate maintenance and membership into a collective bargaining agreement. So behind me, I have examples of the definition in the statute, and I have an example of how the text practically kind of winds up in a CBA. So if we turn here for a second, the important part of this statute I have highlighted here, it talks about how members must remain members for the duration of the collective bargaining agreement, and they have 15 days prior to the expiration of such an agreement to get out. Now the practical application, here's a sample CBA provision over here. we have that the employee or employees may resign from the union during the 15-day window period immediately prior to the expiration of the agreement. So let's put this into a little bit more context. You have a 4-year collective bargaining agreement. You have a maintenance and membership provision in it. And what that would mean for you is that you could get out of the union the last 15 days of that 4-year contract. So out of 4 years, you have 15 days to get out of the contract. And as you may imagine, that's, well, you don't even have to imagine this. For real, it's a small window period, a small amount of time out of a large amount of time. Often the unions don't inform anyone about this, and they make it somewhat difficult to do. They'll put additional restrictions on, saying it has to be a certified letter, you have to hand deliver it to the union office, the sun has to rise twice, the coyote has to howl, whatever. They can put a lot of different restrictions on it, complicating even just the 15-day window period. So this can be a real issue for those who want to get out of the union and become non-members. Now, to the part of, so why does this matter? Why does maintenance and membership matter? This is kind of different, right, from the Janus issue and the forced fees. Well, why it matters is that for someone to claim their Janus rights, they first have to be a non-member. They can't be part of the union. So, of course, the process to become a non-member and not be part of the union now becomes very significant and important. So back in the day, before Janus, where unions could still have non-members pay a fair share fee, an agency fee, whatever they were calling them that day, as you guys probably know, this would be a large portion of the full union dues, typically anywhere from 70 to 90% of what a normal dues-paying member would pay. So the unions weren't overly concerned about having union members because they still got to take money from non-members. Well, now that Janus has come and non-members can choose not to pay anything to the union, union membership is so important. And not only are the unions trying to sign more people up into the unions, they're trying to keep people from, running away from the unions or even just trying to get out of the unions for whatever reason. It doesn't really matter what the reason is. So that's why maintenance and membership has been popping up all over the country, because unions are very focused on this now, and they're very focused on keeping their ranks and their membership numbers high, because that means more money to them at the end of the day. What I thought we'd do is talk through a couple maintenance and membership cases that illustrate what I'm talking about here. These are cases that the Fairness Center is representing clients in. The first case, James v. SEIU, Local 668. We have 3 clients over in Western Pennsylvania, and this is a class action case. And the basic facts, these clients all followed the rules. They sent in their resignation letters, and they are all told, no, see your maintenance and membership provision in the contract. You can't get out except for this 15-day window period. Of course, this was not satisfactory to them, so they came to us. We took their case, and we said, we believe that your constitutional rights shouldn't be limited to a 15-day period every 3 or 4 years. So we're doing that case for them over in the Western District of Pennsylvania in federal court. The next case is Kabler versus UFCW, Local 1776. And this is Mr. Kabler right up here. This is John. And John is a liquor store clerk in Pennsylvania. The Commonwealth controls the liquor store, so he's a Commonwealth employee. And his story is a little bit different. So his story is, when he first got his job, he was told that it was a condition of his employment to be a member of the union, which of course union membership cannot be a condition of employment. So feeling he had no other choice, John joined the union, basically under protest, and was a union member until he heard about Janus. And when he heard about his Janus rights, he quickly tried to resign his union membership so that he could claim his Janus rights. And the union, of course, said, no, you cannot. You must stay a union member until a particular time. And we were happy to, and we are happy to represent John at this time. The next case after that Molina versus SEIU, Local 668. You can see there's a repeat offender there. And this is Mr. Molina right here. He has an interesting story as well. Before Janus, the ruling came out in Janus, what happened there was his union, like many unions, went around trying to get people to sign new membership cards. Although what his union told him and his co-workers was, hey, these cards are defective that you signed. You need to sign new litigation-proof membership cards. And the cards basically only changed in that they said that regardless of membership, these people would commit to paying union dues, whether they're union members or not. Of course, they didn't tell them about that part. The language was just kind of slipped in there. So Mr. Molina did not sign that card. He realized what they're up to. He tried to resign from the union, and if you can't guess already, the theme of all these stories is the union said no. So we are representing him right now. We also have a case called Spanalonis versus SEIU Healthcare District 1199. This is one of our Connecticut cases. It was a federal court case. This is Ms. Spanalonis down here. Her name's Cheryl. And she reconnected with her church and realized that a lot of what the union was spending its money and time on was against her beliefs, so she wanted to resign and send her money to a charity. And she spent 3 years trying to get confirmation whether the union honored her resignation and trying to figure out how can I send this money to charity, and the union just totally gummed it up for her. She got a hold of us. We were able to settle her case pretty quickly, get her all her money back, and now she's a non-member, and I'm very thankful for that. So that was a good resolution and a happy resolution for her in that case. But again, the union said no, tried to keep her from resigning her membership. The final case I have listed up here, and again, these are just example cases. There's more, but the final case is Neely versus AFSCME Council 13. AFSCME is another big player in this who's telling people no pretty regularly. Mr. Neely worked for the Commonwealth. He worked for a state hospital, actually just doing amazing work with the patients there. He also heard about Janus, wanted to resign. They said no. We've since settled his case, but it just is another example of how, how important the maintenance of membership issue is, not just on its own, but helping people to claim their Janus rights. A lot of folks are running into this maintenance of membership issue by trying to get out because they want to claim their Janus rights. So you may be wondering, if maintenance of membership is such a big issue, has this ever been challenged before in court? The short answer is yes, it has been challenged, but the caveat to that is it hasn't ever really made it to a final decision or opinion, something that some of our cases or other cases around the country may end up doing, but typically the unions seem to be a little bit gun shy about litigating these cases. However, why we're so confident in our position that maintenance of membership violates people's constitutional rights is because there's been 2 district courts in this country that have said, when the issue has been placed before them, hey, maybe there's a problem here, guys. And the first court was in the Southern District of California. I'm just going to read you real quick what the judge said there. So it's a case called the Bond. The court said that it is clear that the plaintiff's First Amendment rights are at issue and may be unconstitutionally infringed by the requirement that he remain a member of the union until the expiration of the agreement. Now, the second case was actually right here in the Middle District of Pennsylvania. Same sort of scenario. Employees were challenging the maintenance of membership provision, and we call it the Turnpike workers case. But that case actually cited to this earlier case in DeBont. And again, the judge basically said, yeah, you know what, there's a constitutional problem here. Now, in both these cases, they never made it to the full end, the conclusion of the case, because the unions quickly settled. They didn't want this going any further. But what we do know from these 2 cases is that, at least how the federal courts look at it, is that there may be a constitutional violation by maintenance of membership generally, and that we would certainly say that that would be our position as well, and that's what our clients are trying to get to at the end of the day. So what happens now? Well, there's a couple different ways that this could go. The first way is our clients or some other buddy's lawsuit could make it through the courts, and at the end of the day, perhaps the Supreme Court will say, maintenance and membership is unconstitutional. That'd be one way to put this to rest. Another way is a legislative fix. Of course, we're not in that business, but we certainly would love to see some of these states starting to look through their statutes and their laws and say, hey, this maintenance and membership thing, this is kind of a problem. Maybe we should take care of that at a legislative level. And that would certainly be helpful to our clients and many other employees who would like to resign, but currently are being told, no, you can't resign, you have to stay in the union. So that's all I have for you today. Thank you so much for allowing me to speak with you a little bit about some of the work that the Fairness Center has been involved in and the maintenance and membership issue. I hope that you have a fantastic day, and hopefully we'll see you next year. If you would like to learn more about the Fairness Center, feel free to check out our website. It's at fairnesscenter.org, or you can give us a call at 844-293-1001.
Thank you, Nathan, for that presentation. We truly appreciate going in depth on your cases there and letting us know kind of the impact in Pennsylvania and what is happening. And surprisingly, that brings this conference to a close. It went a lot faster than we thought it would, and that's thankfully in part due to this new interface that we're using, and hopefully you've enjoyed the smooth transitions, the videos, the quality that it is. Feel free to comment on that or send, Kathy some input. The last thing I did want to mention, well, two last things is one, if you have questions about, rights, things like that, our website is www.nrtw.org, as you can see on the screen behind me. Or we have a website after the Janus decision. It's myjanusrights.org, and you can send people to that website. Either one works, as both will provide information to individuals. And the last thing I do want to say is thank you for joining us today and for taking time out. We look forward to having you join us again next year.